just because you suffered injury at the hands of a doctor or hospital staff, does that automatically mean you have a valid case? Would you like to know the answer? Come join me for a walk near the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. The short answer is no. Just because you suffer injury while under the care of a doctor or hospital staff does not automatically mean that you have a valid basis for a case. Now you might be wondering, how is that possible? You might go into a doctor's office and now everything's fine and lovely and they give you a procedure. Next thing you know, you have a permanent injury. So therefore you assume that something must have been done wrong. Now, your assumption might be accurate, but then again it might not. What about the scenario where you go into the hospital for what would be a routine surgical procedure, and now you come out with significant permanent injury? You turn around and say, hey, I went into the hospital, I was just fine, but now I came out and I have all these permanent injuries, so therefore something must have been done wrong. The answer is, not always. There are many instances where a potential client will come to me and say, listen, I went into the hospital, I was fine, and I came out with permanent injuries. So therefore, I think I have a valid case. And now we begin to investigate, and it turns out just the opposite. And again, you might be thinking, how is that possible? You know that your doctor treated you, and you know that you didn't have all these permanent injuries. There's only one way you believe that these injuries occurred, and that was from carelessness. Carelessness of the doctor, carelessness of the hospital staff, and therefore you believe you have a valid case. Well, let me share something with you, and you may not be familiar with it. In order to bring a medical malpractice case in New York, we are required to show three separate things. We have to show, number one, that there was carelessness. There was a departure from the standard of care. Number two, we have to show that that carelessness was a cause of your injury. It doesn't have to be the cause, it only has to be a cause. And three, we have to show that your injuries are significant and or permanent. Now, all three of those different elements have to be confirmed by a doctor who has treated you, or by a doctor who has reviewed all your records and confirms that each one of those elements are present. If one of those elements is missing, there is no way that we can go ahead and bring a lawsuit on your behalf. It doesn't matter how badly injured you were. It doesn't matter the extent of what actually occurred to you. If any one of those elements is missing, we cannot go forward with a case. So, for example, if it turns out that the doctor was not careless or the hospital staff was not careless, and yet you still suffered significant harm and injury because our expert has determined that the care you received was not a departure from the standard of care, we are unable to go forward with the case despite the fact that you may have suffered permanent, irreversible injury. Likewise, if our expert determines that yes, there was clear wrongdoing, there was a departure from the standard of care, now the expert has to determine whether there is a link, a connection between that wrongdoing and the injury that you suffered. There has to be that connection, that bridge. If it turns out that yes, your doctor was careless, but there is no connection, no causal link between the wrongdoing and your injury, guess what? We are not permitted to go forward with a case, and you would be unable to start a lawsuit in New York despite the fact that your injuries may be significant or permanent. Now, what about this scenario? Let's say our expert was able to show that yes, the doctor was careless, and yes, that carelessness was a cause of your injury. In that instance, you might be saying, okay, great, now I have a valid case. Wait 1 second. Maybe yes, and then again, maybe no. The reality is that the level of your injuries may not rise to the level that your attorney who is evaluating your case is willing to take on. There are many cases where the injuries are not that significant. In that instance, you will find it very challenging to find an attorney who is willing to take on a case like yours. And you might be asking yourself, why? Why is that? It's because an attorney will work just as hard on a case that has minimal injuries as a case that has very significant and permanent and disabling injuries. And I will tell you, in my experience, most attorneys will go ahead and only take on those cases that are very serious, are very debilitating, and have lifelong, lasting, and permanent injury. In that instance, if your injuries do not rise to the level that your attorney is willing to take, then in all likelihood your attorney is going to say, I'm sorry, I cannot accept your case and you need to go elsewhere. It is only if your attorney and your expert have come to the conclusion that yes, you do have a valid basis for a case, only then will you be permitted to go ahead and file a lawsuit on your behalf. So why do I share this quick information with you? I share it with you because so many people think that just because they suffered significant injury or they suffered some type of injury as a result of medical care and treatment by a doctor or hospital staff, that it automatically means that they have a valid basis for a case. Hopefully by watching this video you'll realize that that's not the case. You know, I realize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and are thinking about bringing a lawsuit but still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.